custody case.
Yes. So Mr. Stan says, it's not my intent to object to relevance in DV. I want to make sure we litigate the DV issue first and foremost. If there's a spillover of custody visitation, that's fine. But I want to make sure we have the DV dealt with first. That's my concern. The court says, okay, I think we're going to have to take it as it comes. Her lawyer says, sure. Judge says, we'll see as we get into it, we'll see. Worst case scenario is we do the DV, decide it, and come back and we do some. Hopefully that won't be necessary, Ms. Budnick says. And then I guess a couple other housekeeping issues. We do have, I know myself and opposing counsel, both parties have non-party witnesses here. I would ask if the court is inclined to let us call them out of order. We're not going to finish today, so they don't have to come back for another day, and their testimony should be fairly brief. The judge says, I have skepticism about finishing today. Why do you say that? To me, I mean, I've read all the papers. It doesn't seem very complicated to me, to be honest. This judge thought they were going, he was like, what? We're going to wrap this shit up. But I don't think it's that complicated, Ms. Budnick says. I think to the extent we're submitting declarations and everything that's attached to them without objection, I think that would streamline the process. There have been fairly significant, a handful of incidents that have happened since the request was filed that I think my client will need to testify to one of our witnesses here today, or really both of the witnesses have some testimony to offer on these additional incidents. Thank you, Ariel. I appreciate you. Candace, thank you so much. I love you and appreciate you. If we're talking about just the restraining order, I think, yes, we could probably get through that today. If we're dealing with custody and move away, judge says, I don't think move away is going to, Ms. Budnick says, I don't know if move away is, there hasn't been a custody order made. My client, they've agreed to custodial time, as Your Honor probably read in our reply. The court says it's kind of haphazard. Mr. Sands, her lawyer, says that's a polite way to describe it. Ms. Budnick says it is a set schedule. It has been significant amounts of time, but it's been here, which is, the child isn't in school yet. I don't know if, like I said, a move away is the way to phrase it or allowing my client to exercise his time in Texas where he lives. The court says, one other thought, generally, I'd be very receptive to have people taken out of order to the extent I want to hear from them because the parties have told me what I need to know. I'd probably want to defer them a little bit. You want them to be taken today? Ms. Budnick says, yes. The court, why don't we get into it and see where we are? Before we do, I have to tell Ms. Olson, so this is a request for a domestic violence restraining order against you. Restraining orders are civil in nature, and if one is entered and you violate it, that can be a crime. You have to think about that. Bree says, okay. The court restraining orders can have implications for a variety of things, including pew-pew ownership, ammunition ownership, immigration issues, employment issues, any number of things that if you have a restraining order on your record, it goes into your permanent record. And when people check on things like, I know I ran into this in a school environment, your child's not ready for school, but if your child gets to be, W is his name, if he gets to be a kindergartner and you want to be the room parent, they might check and say, well, sorry, you can't because you have a restraining order. These things, can be consequential, okay? Perhaps the most important aspect of it is that under a provision of the Family Code, I don't know if you talked to your lawyer about it or not, Section 3044, it says that it is presumptively detrimental to the interest of the minor to have a person who is found liable for having engaged in domestic violence acts, absent violence, to have sole joint or legal physical custody. So this makes me... Sorry, people keep interrupting the court.
Take ya time, K.
You can pull up and the boys real quick. I'll be right back.
Hello, ma'ams. Ma'ams? Ma'ams. Can you hear me, ma'ams? Is this the right tone, ma'ams?
Yes, Daddy.
Don't want to get out of line here in the court, ma'ams. I don't want to be reprimanded.
You may speak. Stop
Thank
yelling
you.
at me. And the boys,
Objections is irrelevant to this
speak.
case.
Where's
No.
the snacks,
This is
sir?
irrelevant to this case.
Children should be seen and not
Y'all got all
heard.
the snacks. Y'all got all the snacks. I'm not a child. I'm a grown man. Oh, I'm so sorry, ma'ams. I'll keep it down. Court is in session. I don't want to get a contempt charge in here. I'm offended too. Everybody's offended. Why are we offending everybody all the time? We gotta stop. Order. Would y'all got to order? I'm so hungry. I didn't bring any snacks. I'm not prepared for this. I didn't realize we were gonna have 232 pages today.